Hello and welcome to the channel. It's me, Chris Brooks. So for those who follow my channel regularly, you will know of the Thetford Council Watch. The last Thetford meeting that we had at the council meeting, there were a few people calling out in the audience. So I'm not going to mention any names, but some of them are from Thetford Council Watch. But anyway, it transpires that according to an article in the EDP written by Eleanor Story, and I swear that Thetford Council Watch must be keeping this local democracy reporter in a job, because she only ever really seems to report on Thetford Council Watch and what they get up to, which is good, you know, publicity and all that. However, let's read what has been put. Thetford Town Council bans disruptor from meetings. A Norfolk council has begun issuing long-term bans for members of the public after its meetings were repeatedly disrupted by protesters. Councillors have now agreed to ban a member of the public from attending meetings for 1 year due to the individual having been disruptive. The person who has not been named has yet to be informed. So they've gone to the press and they've said about this person, legal fiction, this individual being banned, but they haven't actually notified this person. So that's kind of tells you quite a lot straight away, doesn't it? Thetford Town Council has already excluded one person after a series of chaotic sessions which has been attended by a group of campaigners known as Thetford Council Watch. The crowd regularly attends meetings of the authority to raise topics such as sex education in schools, climate change and the use of vaccines, and council staff have called the police on several occasions in an effort to restore order to these sessions. Just bear in mind that every time the police have been called, the police have done nothing because there's no crime being committed. There's no law being broken. So that's always something to just bear in mind, which I'm sure most of you watching this know anyway. Continued disruptive behaviour, particularly through personal attacks and unprofessional conduct, undermines the constructive discourse needed to address the town's needs and challenges, and ultimately prevents councillors from being able to conduct council business. And this is the thing, this is what people have to remember, is that councils are a business, so they're corporations. Human and public trump corporations. The council will continue to work with law enforcement and legal advisors to ensure that public meetings remain accessible and respectful spaces, safeguarding both the democratic process and the integrity of the council operations. The authority called an extraordinary meeting of councillors this week where they all agreed to ban a member of the public from future sessions. The individual will receive a letter informing them of their exclusion for a 1 year period due to having disrupted meetings of the council. Further notices could be issued if any member of the public exhibits persistent or severe behaviour that significantly disrupts the business of the council at one or more meetings. So, with that in mind, I went onto a website called Councillor Q&A, which is pretty much all what it says. It's about Q&A for questions where town councillors get involved. And one of the questions is, can a parish council ban someone from attending meetings? So here's one example of somebody who has been banned, not the person that I've just been talking about, but this is just a separate incident in another council. But I assume they all adhere to the same woke policies. My local parish council has banned me from attending council meetings for 6 months, including contacting any councillor or the clerk in any way. I asked the clerk a question which she did not like and then provided her proof of what I had asked. She is a locum clerk. If I do, she has threatened me with legal action. Is this correct? Here's one of the answers. Public Bodies Admission to Meetings Act 1960 Section 1 4C states, while the meeting is open to the public, the body shall not have the power to exclude members of the public from the meeting. The clerk is bluffing. There is no legal action that any serious solicitor would take on. Here's another answer. No, it would be unlawful to deny a member of the public access to a public building. In specific, very limited, I understand, circumstances, courts have restricted attendance. Suspect scenarios was along the lines of a police bail and weren't allowed to contact or be near X, who was reasonably likely to be in attendance given place of work. I have seen someone tried to be banned at a council. They turned up and sat down and basically said, call the police. Police did show up and basically ripped into the clerk and chair. So all I would ask Thetford Town Council is, are you being lawful? Is what you're doing legal or lawful? Because obviously there's a difference between legal and lawful. Here's the email that this person received from their clerk with regards to them being banned. So let's have a read of this.
During the last 2 months, you have shown yourself to be destructive towards Council and the business that Council is conducting. This is shown within the minutes which are attached. I have taken the liberty to attach them for Mr. Baxendale's reference. Recordings of the meetings can also be supplied to verify the minutes. During these months, and after your resignation, you have continuously sent in emails which have taken a large amount of time to address. Given the fact that the Council has a locum clerk in post for 15 hours a week, and that the Council is paying for locuming services instead of an employed clerk, it is considered to not be cost-effective to keep dealing with abusive, intimidating emails which serve no purpose. I consider your presence within the meetings threatening and intimidating. The decision was not taken lightly. The purpose of the Vexatious Policy is to allow the Council the right to not reply to any correspondence sent in by whomever has been issued the policy without reprimand. Having never, in my years of clerking, having found the need to issue the policy, I assumed that it would extend to meetings. If the Council has found someone to be destructive, threatening, and/or intimidating, having them present at the meeting would be counterproductive. You are, as you state, free to attend the meetings, but as a Council, your comments and/or questions will not be answered. If anyone were to continue with destructive, threatening and intimidation during the meeting, one of 2 things may happen. They may be asked to stop and leave, or be removed, and/or the meeting will conclude, and Council will reconvene at another point in time.
And for anybody who is interested in the whole vexatious malarkey, then this is the Vexatious Policy, which I assume, again, is across the board with all these councils, as they all seem to enjoy using that language now. So if you're interested, it's about 10 minutes long. This is what the Vexation Policy is. But until next time, look after yourselves, take care, see you again soon.
Vexatious Complaint Policy, reviewed and adopted by e-resolution on the 15th March and approved at full Council on the 20th March 2024. 1. Introduction. This policy identifies situations where a complainant, either individually or as part of a group or a group of complainants, might be considered to be habitual or vexatious. The following clauses form the Parish Council's policy for ways of responding to these situations. 1.1. In this policy, the term habitual means done repeatedly or as a habit. The term vexatious is recognised in law and means denoting an action or the bringer of an action that is brought without sufficient grounds for winning, purely to cause annoyance to the defendant. 1.2. This policy intends to assist in identifying and managing persons who seek to be disruptive to the Council through pursuing an unreasonable course of conduct. 1.3. The term complaint in this policy includes requests made under the Freedom of Information Act 2000 and the Data Protection Act 2018, and reference to the complaints procedure is, where relevant, to be interpreted as meaning a request under those acts. 1.4. Habitual or vexatious complaints can be a problem for Council staff and members. The difficulty in handling such complainants is that they are time-consuming and wasteful of resources in terms of officer and member time. While this Council endeavours to respond with patience and sympathy to the needs of all complainants, there are times when there is nothing further which can reasonably be done to assist or to rectify a real or perceived problem. 1.5. Raising of legitimate queries or criticisms of a complaints procedure as it progresses. For example, if agreed timescales are not met, should not in itself lead to someone being regarded as a vexatious or an unreasonably persistent complainant. Similarly, the fact that a complainant is unhappy with the outcome of a complaint and seeks to challenge it once or more than once should not necessarily cause him or her to be labelled vexatious or unreasonably persistent. 1.6. The aim of this policy is to contribute to the overall aim of dealing with all complainants in ways which are demonstrably consistent, fair, and reasonable. Habitual of vexatious complainants. For the purpose of this policy, the following definitions of habitual or vexatious complainants will be used. The repeated and/or obsessive pursuit of unreasonable complaints and/or unrealistic outcomes, and/or b. reasonable complaints in an unreasonable manner. 2.1. Prior to considering its implementation, the Council will send a copy of this policy to the complainant to give them prior notification of its possible implementation. 2.2. Where complaints continue and have been identified as habitual or vexatious in accordance with the criteria set out in Section 3, the Council will seek agreement to treat the complainant as a habitual or vexatious complainant for the appropriate course of action to be taken. Section 4 details the options available for dealing with habitual or vexatious complaints. NPC Vexatious Complaint Policy 2024 2.3. The clerk on behalf of the Parish Council will notify complainants in writing of the reasons why their complaint letter has been treated as habitual or vexatious and the action that will be taken. 2.4. The status of the complainant will be kept under review. If a complainant subsequently demonstrates a more reasonable approach, then their status will be reviewed. 3. Definitions. 3.1. Nuthurst Parish Council defines unreasonable, persistent, and vexatious complainants as those complainants who, because of the frequency or nature of their contacts with the Council, hinder the Council's consideration of their or other people's complaints. The description unreasonably persistent and vexatious may apply separately or jointly to a particular complainant. 3.
2.
Two examples include the way in which, or frequency with which, complainants raise their complaints with staff, or how complainants respond when informed of the Council's decision about the complaint. 3.3. Features of an unreasonably persistent and/or vexatious complainant include the following. The list is not exhaustive, nor does one single feature on its own necessarily imply that the person will be considered as being in this category. An unreasonably persistent and/or vexatious complainant may have insufficient or no grounds for their complaint, and be making the complaint only to annoy, or for reasons that he or she does not admit or make obvious. Refuse to specify the grounds of a complaint, despite offers of assistance. Refuse to cooperate with the complaint's investigation process, while still wishing their complaint to be resolved. Refuse to accept that issues are not within the remit of the complaints and procedure, despite having been provided with information about the scope of the procedure. Refuse to accept that issues are not within the power of the Council to investigate, change, or influence. Insist on the complaint being dealt with in ways which are incompatible with the complaint's procedure or with good practice, e.g., insisting that there must not be any written record of the complaint. Make what appear to be groundless complaints about the staff dealing with the complaints, and seek to have them dismissed or replaced. Make an unreasonable number of contacts with the Council, by any means in relation to a specific complaint or complaints. Make persistent and unreasonable demands or expectations of staff and/or the complaints process after the unreasonableness has been explained to the complainant. An example of this could be a complainant who insists on immediate responses to questions, frequent and/or complex letters, faxes, telephone calls, or emails. Harass or verbally abuse or otherwise seek to intimidate staff dealing with their complaint, in relation to their complaint, by use of foul or inappropriate language, or by the use of offensive and racist language, or publish their complaints in other forms of media. Raise subsidiary or new issues whilst a complaint is being addressed, that were not part of the complaint at the start of the complaint process. Introduce trivial or irrelevant new information whilst the complaint is being investigated and expect this to be taken into account and commented on. NPC, Vexatious Policy 2024-3. Change the substance or basis of the complaint without reasonable justification whilst the complaint is being addressed. Deny statements he or she made at an earlier stage in the complaint process. Are known to have electronically recorded meetings and conversations without the prior knowledge and consent of the other persons involved. Adopts a scattergun approach, for instance, pursuing a complaint or complaints not only with the council, but at the same time with, for example, a Member of Parliament, other councils, elected councillors of this and other councils, the council's independent auditor, the Standards Board, the police, other public bodies or solicitors. Refuse to accept the outcome of the complaint process after its conclusion, repeatedly arguing the point, complaining about the outcome, and or denying that an adequate response has been given. Make the same complaint repeatedly, perhaps with minor differences, after the complaint's procedure has been concluded, and insist that the minor differences make these new complaints which should be put through the full complaints procedure. Persistently approach the council through different routes or other persons about the same issues. Persist in seeking an outcome which council has explained is unrealistic for legal or policy or other valid reasons. Refuse to accept documented evidence as factual. Complain about or challenge an issue based on an historic and or an irreversible decision or incident. Combine some or all of these features. 4. Imposing restrictions. 4.1. The parish council will ensure that the complaint is being, or has been, investigated properly according to the adopted complaints procedure. 4.2. In the first instance, the clerk will consult with the chairman of the council prior to issuing a warning to the complainant. The clerk will contact the complainant in writing or by email to explain why this behaviour is causing concern and ask them to change this behaviour and outline the actions that the council may take if they do not comply. 4.3. If the disruptive behaviour continues, the clerk will issue a reminder letter to the complainant, advising them that the way in which they will be allowed to contact the parish council in future will be restricted. The clerk will make this decision in consultation with the chairman of the council and inform the complainant in writing of what procedures have been put in place and for what period. Any restriction that is imposed on the complainant's contact with the council will be appropriate and proportionate, and the complainant will be advised of the period of time over which that the restriction will be in place. In most cases, restrictions will apply for between 3 to 6 months, but in exceptional cases, this may be extended. In such cases, the restrictions would be reviewed on a quarterly basis or at the next full council meeting. 4.5. Restrictions will be tailored to deal with the individual circumstances of the complainant and may include banning the complainant from making contact by telephone except through a third party, e.g. a solicitor, a councillor, or a friend acting on their behalf. NPC Vexatious Policy 2024. 4. Banning the complainant from sending emails to individuals and or all council officers and insisting they only correspond by postal letter. Requiring contact to take place with one named member of staff only. Restricting telephone calls to specified days and or times and or duration, requiring any personal contact to take place in the presence of an appropriate witness. Letting the complainant know that the parish council will not respond to or acknowledge any further contact from them on the specific topic of that complaint. In this case, a designated member of staff will be identified who will read future correspondence. 4.6. When the decision has been taken to apply this policy to a complainant, the clerk will contact the complainant in writing to explain why the decision has been taken, what action has been taken, the duration of that action. 4.7. The clerk will enclose a copy of this policy in the letter to the complainant. 4.8. Where a complainant continues to behave in a way that is unacceptable, the clerk, in consultation with the chairman of the council, may decide to refuse all contact with the complainant and stop any investigation into his or her complaint. 4.9, where the behaviour is so extreme or it threatens the immediate safety and welfare of staff, other options will be considered, e.g. the reporting of the matter to the police or taking legal action. In such cases, the complainant may not be given prior warning of that action. 5. New complaints from complainants who are treated as abusive, vexatious, or persistent. 5.1. New complaints from people who have come under this policy will be treated on their merits. The clerk and the chairman of the parish council will decide whether any restrictions that have been applied before are still appropriate and necessary in relation to the new complaint. A blanket policy is not supported, nor ignoring genuine service requests or complaints where they are founded. 5.2. The fact that a complainant is judged to be unreasonably persistent or vexatious, and any restrictions imposed on council's contact with him or her will be recorded and notified to those who need to know within the council. 6. Review 6.1. The status of a complainant judged to be unreasonably persistent or vexatious will be reviewed by the clerk and the chairman of the parish council after 3 months and at the end of every subsequent 3 months within the period during which the policy is to apply or by the next full council meeting. 6.2. The complainant will be informed of the result of this review if the decision to apply this policy has been changed or extended. 7. Record keeping 7.1. The clerk will retain adequate records of the details of the case and the action that has been taken. Records will be kept of the name and address of each member of the public who is treated as abusive, vexatious, or persistent, or any other person who so aids the complainant. NPC, Vexatious Complaint Policy 2024-5, when the restrictions came into force and ends, what the restrictions are, when the person and council were advised. 7.2 Full council will be provided with a regular report giving information about members of the public who have been treated as vexatious persistent as per this policy.